Whatever the outcome of the Commission, the government, without any reservation, will accept its findings. And in light of the finding, if the country will have to go for an early election, then the government will always submit to that finding. Yeah.
Thank you. Thank you, committee members. Good morning once again. I would also like to thank the committee members for the comments that was raised yesterday on the reporting mechanism and the format of our treaty reporting. I'd just first like to say that Maldives, as being a small island state with a quarter of a million, over 300,000 people, so it's the limitation in terms of capacity to report on our obligations. It seems a huge, constraint, and it also makes it very difficult for many small island states, especially our countries who have very few, people who have been trained on this kind of international conventions and just to handle human rights issues. Starting from that point, I would also like to comment on the Common Core document. We have maintained a Common Core document, as I think distinguished members would see, that this document has been developed with the assistance of a human rights advisor who was, I think, facilitated by the OHCHR. Government of Maldives requested for such assistance because we had a lot of pending treaty obligations. We were not able to report on our treaties, and hence we requested such assistance, whether they will be able to develop as a model in which we will be able to come on reporting under each convention. So this is the first, I think, issue of addressing on treaty obligations. And the Foreign Ministry, with its capacity at the moment, and has been for a very long time, having only one person dealing with such human rights issues and also on responding to treaty obligations. So that is another concern for us. However, the government of Maldives, my government, would like to honor the treaty obligations, and this is why we have made sure that we did develop this Common Core document with the assistance of the OHCHR advisor. And in order to also meet the treaty deadlines, we ensure that along with the Common Core document, we will have a small treaty reporting which will add on whatever developments that have taken place. We also welcome the comments that were, comments and suggestions that were put forward by the committee members. I think this is very helpful as we are working in progress, and we would like to learn and benefit from other experiences, but in order to also match and balance what kind of capacity we have, and also meet the international obligations on treaty reporting. The OHCHR has been requested by the government of Maldives to place another human rights advisor, and signaled going to be shortly. We have welcomed that, and we would also like the advisor to work with the Maldives Foreign Ministry and our stakeholders, as well as the Human Rights Commission, so that this will also build on how competent we are, and also to address these issues as sufficiently as the committee members require us to do. And in order also to say that with the specific reporting under each treaty, it is an intensive work that we have to do. So I think in future we will also try to update whatever that is available at that point of time, but still try to maintain this Common Core document. A lot of countries like Australia has also followed this model. Maldives followed this model, and it has been very helpful for us in order to actually come up with all the treaty obligations. The committee members' comments specifically to my delegation has also made us aware that in future we should also try to somehow come up with a treaty reporting that will address the ongoing issues or current updates that are there, and also improve on our written reporting mechanism. So we would like to look into that, and we'll of course be speaking to our stakeholders on this issue. But I just would like to say that this is the reason why we have a common core document. Maybe not all countries have, but just the small island developing countries which are constrained by the enormous task that is put forward before them. But I think we have done quite well. My government has been able to present last year on the 3rd, and we are here today, responding to ICCPR. This shows our keen interest and commitment to address to our treaty obligations. I thank you, treaty members.
Madam Chair, I just want to add also on the comment made regarding the government retracting on the promise of earlier elections. I think there is a misunderstanding here. Definitely following the transfer of power, there was a lot of discussions and sort of pressures also on Maldives from many areas. However, our President has made it clear he has established an independent commission looking into issues of transfer of power. So before the findings come out, I think there is no room or scope for discussion on election dates. According to our Constitution, the next election is in 2013. In order to bring it ahead, we would need an amendment to the Constitution, and this is not a simple matter. It requires 2/3 majority of Parliament in order for the amendment to be passed through. However, the government has already committed, saying that depending on the findings of the Commission of National Inquiry, should there be a need and should the political parties agree on this, then we would be going ahead with bringing in this amendment. But I think we have to wait and see till end August, till the Commission findings come out. And I think it is not right to pronounce guilty something that has not been investigated purely based on allegations of our political opposition at present. So I just wanted to clarify that and to explain that once again. Thank you.
Thank you. Again, to the question of freedom of religion and expression, and relating to one instance whereby Mr. Rashid, an attack on Mr. Rashid, this on the basis of the things that he has written on his blog and on the opinion he has expressed publicly. I want to explain to the committee that again, there's no particular motive has been established so far. As I explained earlier, currently the entire society is struggling to cope up with the surge of a crime as in general in the society, and it has seen no difference or discrimination between its victims. We have seen young, old, women, children, and in recent and as recent at last, the last victim was a prominent lawyer in the country. And in each instance, we have witnessed some more grievous offences has taken place. For example, as recently as this month, the prominent lawyer was murdered. So again, the investigation has been going on this relevant case as well. We have seen that he was also being subjected to target during 2010 as well, and in that particular instance also the government of the time has tried to investigate, and in one instance I think he was also detained for a short period of time. So it is not for us to yet to determine the motive or intention of particular attacks that was carried out on him. Now, coming back to one question that was again raised yesterday about torture being systematic and the apparent lack of venue to address these grievances. Let me explain to the committee that as any other society, as I have explained, that the very reason why we have seen a very progressive constitution in the country and many other relevant pieces of legislation, and been vigorously pursuing international convention, is that we want not to repeat the things that has happened in our history and in the past. And we want to move on and live as a democratic and Islamic society. And in these instances, with this regard, we have seen, for example, the current constitution very clearly provides different provisions with the intention of providing safeguards against torture and cruelty. For example, Article 16 of the Constitution very clearly says that the rights that are enshrined in the Constitution be interpreted, one, harmoniously in a modern society, second, subject to Islamic Sharia. Second, other than Article 16, Article 48 of the Constitution very clearly says that no individual should be subjected to arbitrary detention and arrest. The reason why we have brought all these detailed articles into the Constitution is based on the experience that we have all experienced in the past. And Article 49 of the same Constitution, again, states the ground of arrest. This is, again, in terms of a Constitution, rare to be seen, because in all other jurisdictions they may have they may have legislated this in a separate piece of legislation, most possibly in a criminal procedure court. But in our case, we have enshrined all these relevant provisions in great detail in the Constitution, simply because we do not want to experience the things that we have, as I said, experienced in our long history. And as a result of that, I must say there is a broad mechanism, a very systematic, broad and wide mechanism currently available within the judicial and legal system of the country. In terms of the constitution of the country, for example, it provides, as I said, several provisions. In addition to these articles, Article 68 of the Constitution is very important, because it very clearly says any right that are enshrined in the Constitution should be interpreted in line with the way that it is being interpreted in modern, progressive and open democracies. And it should also harmonize to the conventions that the Modis has subscribed. And again, Article 69 of the same Constitution interestingly says, while interpreting these rights by any tribunal or judicial body, it should not interpret in a way that would narrow down or that would limit these rights. So attempts have been made to address all these grievances. Other than constitutional provisions, as I said, we have an independent judiciary, we have an independent prosecutor general. Previously, the prosecution was attached alongside with the Attorney General's function. But since Attorney General sits as a cabinet portfolio with the cabinet, this is being separated in the Constitution, and the office of the Prosecutor General is being made as a constitutionally independent body. That is also to answer such grievances and to the responsibility of the prosecution to be carried out independently. In addition to that, we have our Human Rights Commission, as I said repeatedly, and we have other mechanisms in place, such as Police Integrity Commission. So I would say, for a small nation, for a country that did not inherit a legal system from its colonial masters or from its protectorates, this is a huge leap forward in terms of the piece of legislation that we have as a constitution, and a number of legislation that is being produced every day in the Modis. And the Parliament has been really busy producing and answering all those questions that have been raised in the society. Thank
you. I think the head of delegation has given his viewpoints and explained clearly on the issue of torture. I just wanted to add that it is not right to say that Maldives has a history of systematic torture. I think this has become a very politicized issue, and there are many false allegations that are given, and it is unfortunate that it has sort of developed into, the politics has come into it. However, the government is committed. We have a new constitution in place and the independent bodies in place in order to address any issues or instances that may arise, and we should really look forward in terms of ensuring better rights for all, including those in detention and otherwise. I think we will now pass the floor. The head of delegation wishes to say something, but on my side, let me thank you all for the very constructive comments and dialogue, and we look forward to
for a final comment, with the permission of the chair, let me also explain one of the questions raised yesterday with regard to domesticating the international conventions into the Maldives legislation. As one of the questions was posed to us, is that the Maldives constitution subjects every international conventions before it takes effect domestically to be ratified into a different piece of legislation by Maldives Parliament. And with this regard, there was an observation made that regardless of being made, being domesticated in that process, the convention should prevail over the domestic legislations, or the features, the characteristics, the principle of the convention should carry effect in domestically. I would tend to accept these. I have no hesitation on accepting this. But as we all understand, these are debates, academic debates that goes on even in the academia, as to incorporation and non-cooperation of particular international covenant is important or not. We are not the only country which, in my understanding, has similar provision in its constitution. Others also carry similar provisions. But as I said, the reason why these provisions were provided in our constitution is basically because the understanding that democratically elected representatives should have a say before imposing any kind of obligations on its people, and that's the reason why the Maldives constitution very firmly says this domestic legislation should be made to take effect of the international conventions. I think I've tried to answer all relevant questions, but before concluding, I would welcome the comments made by honourable member with regard to inviting Maldives to observe and to get, if possible, consultation with progressive Islamic interpretation of the laws and that takes place around the Muslim world. We are always welcome, and we always welcome to such invitation and initiatives. In fact, we have always tried to do that in the process of the Maldives constitution. For example, drafting stage, we've invited different international Muslim scholars, including Professor Hashim Kamali, is one of the renowned Muslim scholars of the jurisprudence,